Good afternoon, everyone. Thank you for attending today. Welcome to our Wednesday webinar. Birkett Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. By way of introduction, I'm Tej Thacker and I'm the Head of Regulatory Law here at Birkett Long. This week we're looking at motoring offences and 10 things everyone needs to know. We will take questions at the end of my presentation, so do please make use of the Q&A facility. Next slide, please. Invariably, there are a multitude of individuals driving on the roads in the UK on a daily basis, and there will be a marked increase in the same as we seek to exit the pandemic and people are progressively returning to work. Motoring offences are a common occurrence, and often they are the only circumstances upon which some individuals become concerned with the criminal justice system. There are a wide and far-reaching range and types of motoring offences, for example, driver, vehicle, documentary or licence, that can possibly have devastating consequences for individuals, and this can be twofold. Either number one, due to the severity of a particular incident itself, or secondly, otherwise as a result of a minor contravention in the context of an individual's overall driving record. Therefore, it's important that individuals confronted with any such situation understand the position and make informed decisions about how they proceed, whether themselves or with the benefit of legal advice and representation, whether to properly contest an alleged offence, or alternatively achieve the best possible outcome in any prevailing circumstances, with the view of naturally preserving their ongoing ability to drive. The Road Traffic Act 1988, which I'll refer to as the Act, and the Road Traffic Offenders Act of the same year are the primary pieces of legislation that consolidate motoring laws. It applies to all vehicles and drivers in the UK. As you'll appreciate, it's simply not feasible to touch upon all of the areas and issues that may arise. However, today I'll seek to give you a broad overview of 10 key issues, starting from the outset when the police become involved, through to court proceedings when alleged of a road traffic offence, and finally the potential outcomes. So you should have on your screens the agenda for today's presentation. If you go to the next slide, please. As you'll appreciate, the information in this presentation is going to be for general purposes and is accurate as of today, but is subject to legislative changes and is broad rather than dealing with somewhat unique circumstances. Next slide, please. So dealing with accidents, being involved in an accident or a similar road traffic accident, incident akin to the legal definition of an accident is something that all drivers plainly dread, but is more common than we think. No doubt all of us have heard of those or even experienced those instances about different drivers who have been involved in an accident that either haven't received all the insurance information or simply the other drivers refuse to provide it, or the other party hasn't even stopped, or even worse, when you've come out and you've noticed your car being hit by another vehicle. The reality is that not many people know what the law actually requires in the event of a specific accident. In most cases, it's abundantly clear as to what is meant by the term accident. However, it perhaps is wise to mention that from a strict legal perspective, it also includes those instances where a particular vehicle does not itself have direct contact, but the manner of their driving causes another to take evasive action, resulting in their having an impact, such as mounting a verge or alike, but causation would need to be demonstrated between the two. In such circumstances, the initial vehicle would be deemed to have been involved in the incident, therefore constituting an accident. The law concerning road traffic accidents is contained within section 170 of the Road Traffic Act, and it confirms that if, owing to the presence of a motor vehicle on the road, if the damage is caused to a third party other than the driver or his own vehicle, i.e. persons, animals, vehicles or property, then the drivers who are involved must first stop driving and remain at the scene for a reasonable period of time to comply with or otherwise fulfil the remaining obligations. You may think that stopping after a crash is an obvious and common sense approach, but there are instances where the driver concerned may simply not be aware. If you know that you've crashed and you stop, even if there may not be anyone around, the law says you must wait there for a reasonable amount of time. Now, naturally, there's a lot of factors that can determine what classes as a reasonable time. For example, the time of the day, what road you're on, where you are. But ultimately, the obligations do not extend to searching out people who might be entitled to information, for example, knocking on doors in the area and such like. If there is someone present, you need to exchange the name and address of all the drivers involved, or anyone who's got reasonable grounds, and exchange the name and address of the owner of the vehicles. As you'd appreciate, the driver is not always going to be the owner of the vehicle, for example, if it's a company or work car. And you also need to exchange information about the registration numbers. To make sure there's no mistakes or cloned number plates or anything to that effect, it's always best, in my view, to take a picture of the number plate and the vehicle, in particular showing the colour of the vehicle. In the case of an injury, a personal injury, there's an additional requirement to produce a certificate of insurance or security to any person with reasonable grounds to require those details, and that's the bit where people usually have the biggest problem. The law is very specific in that it states that a current and valid certificate of insurance need only be produced if an injury has occurred, and that all of the parties involved understand that there's an injury. One instance of this is when there is a crash that appears to be a damage only, damage to the vehicle incident itself. But a few days pass and one of the participants start to feel the effect of whiplash. At the time of the crash, there are no apparent injuries, so there was no obvious reason to exchange those insurance details. However, in a lot of cases, it will be obvious if someone has been injured in the road traffic accident, and the legislation states that the insurance details should be given to anyone with reasonable grounds to require it. However, if the law is not complied with, or it's simply not possible to comply with it for any reason, then the drivers must report the incident to the police, and they must do that as soon as possible and in any event within 24 hours. I think there's often a confusion. People think you have 24 hours to do it, but if you drive past 5 police stations but still report within 24 hours, technically you are falling foul of the legislation. The requirement is to do it as soon as possible. And I make reference to driving past police stations because reporting the matter to the police over the telephone isn't sufficient. It has to be at a station, it has to be in person. Now, there is a potential defence to failing to stop or failing to report if you can demonstrate that you were genuinely unaware of being involved in the accident in the first place, or that you simply weren't aware that any damage or injury arose to a third party. However, they are fairly technical issues, and it would be prudent to obtain guidance on those options and implications before presenting any such defence if you are alleged of it. If you are prosecuted and convicted for either failing to stop or failing to report, then the court can deal with it by way of anything between 5 and 10 penalty points or a driving ban. In addition, you can be fined, ordered to pay prosecution costs and such like. It's worthy to mention that fail to stop and fail to report are actually distinct offences. They are confronted as 2 separate charges, so to speak. So whilst 2 offences are committed, they arise from the same factual matrix, they arise from the same factual incident, and so the court, when dealing with it, would only punish or impose a sanction for one of them. However, for all intents and purposes, 2 offences will be committed and 2 offences will be recorded on your licence. In view of the different outcomes and range of sanctions, it is important to prepare the defence or mitigation in response to such a charge carefully, especially, for example, where the imposition of points could result in you accumulating 12 points within a 3-year period, thus rendering you liable to a driving disqualification for a minimum period of 6 months. And that's under the totting up provisions, and we'll come on to that at a slightly later time. So what about where there hasn't been an accident or an incident, but the police want to pull you over? If we go to the next slide, please. I think it's fair to say, regardless of whether you're a newly qualified driver or someone who's been driving for a number of years, it's likely that you've never been stopped by the police on the roads before, or if you have, it's been infrequently, one would hope. As such, the sight of blue flashing lights and a vehicle attempting to pull you over can somewhat be daunting. And the question is, what do you do next? Not knowing can cause drivers to panic and make silly and potentially dangerous mistakes. So it's vital that you know what to do when you get pulled over by the police. And I'm going to start first with what to do when you're pulled over in a marked police car. When it comes to being pulled over by the police, sometimes it's pretty easy to see why you've been asked to do so, regardless of whether it's for an emergency or you're simply late for work. Events such as speeding, undertaking, not using signals, hogging the right-hand lane, tailgating, or simply having road rage are more than likely to be surefire ways to get pulled over. In other situations, however, it can be less obvious why the police might want to pull you over. The question many drivers have then is, when are the police allowed to stop you as a driver or a motorist? In short, the police have the powers to arrest someone anywhere at any time, including on the street, at home or at work. So in short, the police can pull you over whenever they want to. In most cases, if the police car wants you to stop your vehicle, they'll just start flashing their blue lights and possibly start their siren. They'll then use their left-hand indicator to let you know that you need to pull over. Once you get the signal from the police to pull over, you need to calmly assess the situation and the road ahead and find a safe place to pull over. No matter how tempting it is to just slam your foot on the brakes, you need to remember where you are. If you stop suddenly, the vehicle behind you may well collide into you and no doubt cause a domino effect. And as you can imagine, on a dual carriageway, that's going to have cataclysmic consequences. Ordinarily, the police asking you to pull over won't just do it on a whim. They'll try to make sure there's a safe place nearby to stop. And of course, if you're near a bend or driving up a hill, then you'll need to keep going until you find a better place. If this happens, you should signal to the police so that you're following their request. That way they won't make any assumptions that you're trying to make a quick getaway or such like. Once in a safe place, do all your round checks, indicate and come to a stop. Now, there are many motorists who think you must exit the vehicle when pulled over by the police. In fact, the best advice is to stay seated inside the car. Instead, you're suggested to switch off your engine, roll down the window and switch on the interior light if it is dark outside. Now, no one wants to be pulled over by the police, of course, and whether you're in a rush or simply want to put the whole episode behind you, it's vital you keep things polite and respectful. Being impatient or plainly rude won't help the situation, and if they do end up charging you with something, there's little point seeking to dispute it with them at that stage. You're almost better off to wait until you have an opportunity in court. Once speaking to the officer, the best approach is to be polite, but keep responses short and to a minimum. And that's certainly the case if you've been cautioned at the roadside, because anything you can say thereafter can and would be used as part of the allegation. Now, the position and approach may well be somewhat different if the police are in an unmarked vehicle and seeking to pull you over. Unmarked police cars are still allowed to ask drivers to pull over. However, the police officer in question has to be wearing a uniform in order for it to be legally carried out. That said, you may still be wary as to whether or not it's a genuine police vehicle anyway. Now, experts suggest slowing down but continuing on your way if you're unsure. Putting on your hazard warning lights or indicators could let them know that you have acknowledged their existence and they are there. Try to let them know you are not racing away from the scene. Now, another suggestion is to get a passenger, if you have a passenger in the vehicle, to phone the police. They can inform them what's happening. But you should pull in at the first petrol station, for example, if you don't have a passenger or able to make a call using your hands-free kit. Naturally, it's best not to use your phone because you'll be accused of using your phone whilst driving. Now, petrol stations are great places to stop. They often have CCTV cameras. They're installed, and there's lots of people frequently around. Now, it's best still not to open your car window when you're stopped and they approach. You can simply wind your window down an inch or so and ask to see their police warrant card before you engage in the situation further. And you know, given recent events in the headlines, that's to ensure that they are not police imposters, so to speak, and they are who they say they are. Once the police have pulled you over, now they are allowed to ask to see your driving licence, your insurance documentation, and your MOT certificate. The reality is you're not going to have it to hand, but don't worry. If you're not carrying those documents in the car, you are usually allowed up to a week to produce them at your local police station. There are many things that can happen once the police pull you over. They're within their rights to give you a vehicle defect notice, for example, for a defective tyre, an unroadworthy vehicle and such like. An on-the-spot fixed penalty if you've committed a minor motoring offence such as careless driving, no seatbelt, using your mobile telephone. They can issue you a traffic offence report, which effectively says what the offence is if they deem it to be more serious and are looking to send the matter either for further consideration or for court proceedings to be initiated. And ultimately, they can ask you for a preliminary roadside breath test, either a drug swab or impairment test, or an alcohol preliminary test if they've got reasonable grounds to believe you're above the limits. Or in fact, if you've been involved in an accident, and the caveat to all of that is if they think you've committed a driving offence. Now, usually if the police pull you over, it's because they think you've committed a driving offence. And that's actually the only requirement they need in order to ask you to undertake a preliminary roadside breath test. Now, it's worthy to mention at this stage that a failure to comply with that requirement both for a preliminary test, but also a subsequent evidential specimen, if you failed that initial test, is an offence in its own right, unless you have a reasonable excuse. And from a legal perspective, what constitutes a reasonable excuse usually is a physical or medical reason, a phobia of needles, an inability to blow adequately into the device. A a reasonable excuse does not amount to I've not been drinking, I've told you I've not been drinking, and therefore I don't want to comply. Now, in the most extreme situations, you might also face the prospect of your vehicle being seized by the police if you're suspected of driving without insurance or having an in-date MOT, or your vehicle simply deemed unroadworthy. Likewise, if you're causing an obstruction or driving otherwise in accordance with the licence you've actually got, they may well seize your vehicle, preventing you from driving further. If we could go to the next slide, please. Now, usually road traffic offences don't lead to an arrest, save for some limited circumstances. But in essence, to arrest you, the police need to have reasonable grounds to suspect you're involved in a crime for which an arrest is necessary. And I've identified necessary as the key feature there, and that includes whether you've provided false details to prevent physical harm, i.e. if you're intoxicated, loss or damage of the property, or to prevent the investigation or an offence or prosecution being hindered. Now, usually, in most circumstances, your arrest will be linked to either drink or drug driving related matters, and that's because they require an evidential specimen. The roadside failure simply indicates you are over the limit. It does not give them the evidential reading that they need to then bring proceedings before the court. If you are arrested by the police, there are certain things that they must do. They need to identify themselves as the police. That may be somewhat obvious. They need to tell you that you're being arrested. They need to tell you what crime they think you've committed, and they need to explain, and this is important, they need to explain why it's necessary to arrest you. They need to explain to you that you are not free to leave, and they need to ensure that you understand all of those matters. Now, if you try to escape or become violent, which is usually unlikely, however, I put it in the context of drink drivers that are usually aware whether they are over the limit, usually aware of the consequences, and are usually impaired to the extent that their judgment is somewhat impaired. But if they do become hostile or seek to get away, then the police can use reasonable force. For example, they can hold you down, they can handcuff you, and once you are arrested, the police do have powers to search you, and there've been often cases, certainly in drug drive cases, where people fail a test. As a result of their arrest, they are then searched. They are equally prosecuted for possession of a drug and such like. If we go to the next slide, please. I'm going to deal with notices of intended prosecution. Section 1 of the Road Traffic Offenders Act provides that a defendant cannot be convicted of certain road traffic offences set out in the Act unless he or she has been warned that the question of a prosecution would be taken into consideration. Such a warning is normally known as a notice of intended prosecution. Now, that can either be given orally or in writing at the time of the offence was committed. So either you can be told you are being suspected of a prosecution at the relevant time and formally cautioned, or the traffic offence report, which is the yellow slip document that they fill out, that has the pro forma wording on there. But such a warning doesn't need to be specific. It just needs to refer to one or more of the offences that applies. Whether such a warning is actually given is a question of degree, and I'll come on to whether that forms a defence or not. But often the higher courts will not seek to go behind the evidence of a magistrate's court in reaching a finding, as long as there's some evidence to support it. The other way of dealing with the notice of intended prosecution, or NIP as they like to call it, is by just simply issuing a summons to the individual motorist within 14 days of the offence. The alternative is by sending a notice within 14 days of the possibility of a prosecution, and that will specify the nature of the alleged offence, the time and place where it is alleged to have been committed, and it can be sent to the driver, the registered keeper, or the vehicle, and it only needs to initially be sent. So if you have an instance where it's been sent to the registered owner keeper and they've nominated someone else, the 14-day rule is complied with, even if the actual driver subsequently receives it sometime thereafter. So I said obviously that this warning or notice of intended prosecution needs to be given, and that applies to cases of dangerous driving, careless driving, leaving a vehicle in dangerous position, disobeying certain traffic signals, using a mobile telephone, and speeding offences. They are predominantly the types of offences that it applies with. Now, if you receive a notice of intended prosecution in writing via the post, it will specify the offence type, date and time, and it's most frequently used for speeding offences where they're captured on automated or stationed camera devices, but are also used following complaints to the police of poor standards of driving. The NIP will usually be sent first to the registered keeper of the vehicle, and that's as registered with the DVLA and appears in the V5 logbook. And it will be sent to the last registered address of the keeper. There won't be any cross-referencing to your licence, so it's important that those details are kept up to date. There may well be errors in the notice, such as spelling mistakes, inaccurate road names or such like, but the reality is they do not automatically render the notice invalid. The question any court will ask itself is whether the person who's receiving it properly understood what was being asked of them. The person addressed on the notice must respond to it within a period of 28 days from the date of receipt. You can request photographs from the police, and often they do provide them now, but they're not obliged to do so. In some instances, they are not overly helpful due to the camera positioning, lighting, and such like. But if you've spoken to the police over the telephone, again, it's not good enough. You've still got to comply with the notice on the form. I've had cases where clients respond in a letter and they've still been prosecuted because the form makes it clear you've got to fill out the form, it's got to be signed. And the reason they do that is it removes any loopholes or arguments regarding admissibility of evidence if the matter gets that far. People are always advised to keep a copy of the notice and send it by recorded delivery. Believe it or not, the police do lose documentation and allegations follow. If there is a failure to fully respond or comply with the requirements, the courts deal with it by a mandatory 6 penalty points and a fine up to £1,000. If you simply cannot recall who the driver was, you still have to comply with the notice and fill it out to that effect. But there is a defence for failing to identify if you can satisfy a court that it's been impossible to establish the identity, despite completing all reasonable and diligent inquiries. Now that test is for individuals and it differs somewhat for companies. There's a higher expectation on companies. But the critical issue is what is reasonable and diligent, and why those inquiries that you carried out did not identify who the driver was. Now, if you didn't receive the notice of intended prosecution, if you didn't receive it, you quite simply cannot identify who that person is within the time limit. Now, if you accepted that you were the driver despite not receiving it, prosecution follows. If you accept you were the driver and it's a 3-point speeding motoring offence, you may well be able to reach a compromise with the prosecution / the police, which is please drop the allegation of failure to respond and I'll plead guilty to the driving, 3 points rather than 6 points. However, if you are willing to attend the hearing and can satisfy the court that the notice didn't arrive, then you may well have a full and valid defence. You've got to bear in mind that if you are accused of speeding as well as failing to respond and identify the driver, and the police have no further evidence, they haven't got the evidence to confirm you were the driver speeding because you haven't filled out the form, and likewise they haven't got evidence to support a prosecution on failure to identify the driver, either because you didn't receive the NIP or you received it but through inquiries you confirm you were not the driver but you don't know who the driver was. Now there are some caveats to all of that. If there's an accident, that requirement to issue a warning or notice of intended prosecution is evaded. There is a presumption of service of notices of intended prosecution until raised otherwise. And if the police fail to give that warning, it's not an automatic bar to a prosecution and indeed a conviction. If in certain circumstances it arose because the name and address of the accused or the registered keeper couldn't be ascertained by the police with reasonable diligence and in a reasonable period of time. If you as a defendant contributed to that failure by any way, shape or form, or your own conduct, or if the prosecution are taken by surprise about the legal issue when it gets to court. As I've said, you can reduce the penalty points for that offence if the prosecution are willing to accept a withdrawal of that charge if you are pleading guilty, for example, to the initial index charge. If we could go to the next slide, please. So this deals with interviews under caution. Now, if you've been arrested after a motoring offence, as I say, usually for drink drive, they are strict liability. The evidential reading is sufficient. There's often not an interview process unless you've communicated to the police or medical practitioner, if it's at a hospital, that there's a physical or medical reason why you cannot provide a roadside breath test. So many road traffic offences will not require a driver to attend a police station for a recorded police interview under caution, as they're dealt with by summons or a single justice procedure notice. However, there are certain and indeed somewhat limited circumstances when the police do intend to interview drivers suspected of an offence. For example, where there are claims of an accident or careless driving or dangerous driving. Now, during the investigation stage of a driving offence, the police will often contact the named identified driver to ask them to provide that information and attend a formal interview. It's on a voluntary basis, and it can be at the police station, it can be at your place of work, it can be at your home, it can invariably be anywhere. Now, in cases where a suspected motorist is invited or required to attend such an interview, it's important to obtain legal advice, whether privately or actually free of charge through the duty solicitor scheme, since it can often mean the difference between being charged or not, or in fact the severity of if you are charged, for example, whether you're going to be charged with careless driving or dangerous driving, and the basis on which any defence is raised. Likewise, in the absence of understanding your rights or the specific ingredients of the actual offence, a suspected motorist going into an interview thinking it's a friendly conversation, so to speak, can actually self-incriminate themselves and severely prejudice their case at a later stage. One thing to note, certainly in motoring cases more than anywhere else, is where it's usually clear if an offence is carried out or not. The predominant reason the police would want to interview a driver is when they are missing the evidence of a fundamental point needed to prove an offence or disprove any applicable defence, and therefore gain evidence to proceed with a charge against you. With regards to the latter part of those two aspects, it's necessary to consider what is specifically meant by formal caution and the interview under caution under PACE. In the interview, you will be told that you do not have to say anything, but you will also be warned that if you do not mention when questioned any defence or explanation that you might have, then it will harm your defence should the matter go to court. Therefore, if the matter proceeds to court and you raise facts that you could have alluded to or otherwise referenced at your interview stage, your silence to that effect could have an adverse impact on the prospects of success. So the interview process is usually audio and visually recorded. And following the caution, the police will proceed to put the allegations, facts or documentation to you, together with their lines of inquiry. And now it's important to note you've got various options at the interview stage. For example, before the interview starts, you can ask for pre-interview disclosure, and the police don't necessarily have to give it to you, but if they're expecting a response, you need the opportunity to consider what they're going to present to you in the course of an interview. Having then started the interview, you've got various options. You can answer all the questions that they put to you. You can make no comment and not reply. I think the TV, you see suspects saying no comment, but effectively you can sit there in absolute silence and not make any response to any questions. The third option is you can answer the questions that sound nice and you may have answers to, and you can not answer the questions that are difficult. Some would say it's perhaps a giveaway if you're not answering the difficult questions. Now, the fourth and final option is probably my most advised approach in the majority of cases, and that's to address the allegation by way of a prepared statement. That's a written statement that set out your account, and it's drafted in conjunction with your solicitor. It's read out and provided to the officer during the course of the interview, and thereafter the officer is informed that you're going to exercise your right to silence. Now, yes, the specific approach to be adopted usually depends unique to the circumstances of the case, but adopting that prepared statement approach means you are giving information, advancing your position in a managed way, i.e. not to self-incriminate to a degree, to raise the issues you want to raise, and to ensure you're preserving your position should the matter go to court at a later stage. Following the interview process and following all the reasonable lines of inquiry, CCTV checks, speaking to other drivers, all of that jazz, the police and the CPS will make effectively a charging decision, and it's a two-pronged test. Firstly, is it in the public interest to prosecute? And for motoring offences, given the number of motoring offences, given the impact, road safety, that's usually always met. The next stage, which equally needs to be met, is the evidential stage. And in a criminal court, to be convicted, the court have to be satisfied, and so that they are sure beyond reasonable doubt. It's a high threshold. But in order for the test of the threshold to bring charges before a court, the test is one of 51% or more. Is there a realistic prospect of conviction? So it's on the balance of probabilities. It is a lower threshold, and just because a decision is made for you to be charged does not necessarily mean you will be convicted. If we could go to the next slide, please. So court proceedings. You've gone to the interview. Police have made their charging decision. Decision has been made to issue proceedings against you. Now, many road traffic offences are purely summary only, i.e. they are heard in the magistrate's court, and in most cases proceedings are taken by way of laying an information and the issue of a summons. So hence time limits are of particular significance, since for various reasons substantial delays can occur, and in fact do occur, before it's decided to institute proceedings. The point must also be borne that if it's intended at a later date to add further charges, then that you always need to keep one eye on that time limit and if it applies and how it applies. Section 127 of the Magistrates Courts Act 1980 states that for all summary offences, the information must be laid within 6 calendar months of the commission date of the offence, except for where any other act expressly states otherwise. Now, the following needs to be pointed out. The 6 months of laying the information is for the court to be communicated that the charges are being brought. It's not for you to receive the charges. In computing the limitation period, the day of the offence itself isn't included. That may seem somewhat elementary or technical, but there are often cases where the police either get it one day right or one day wrong. And so it's important to look at those time limits carefully. However, a tactic perhaps historically used by the police, which is laying the information within 6 months before actually deciding whether or not to prosecute, can amount to an abusive process and result in the entire proceedings being stayed and a legitimate charge actually being thrown out based on that technicality. Now, I said the 6-month time limit applies to most summary road traffic offences. There are statutory exceptions, and in particular Section 6 of the Road Traffic Offenders Act provides special time limit for offences listed within Schedule 1 of that Act. When it applies, proceedings must then be brought within 6 months from the date upon which sufficient evidence came to knowledge of the prosecutor to warrant proceedings, rather than the commission date of the offence. But in any event, even with that caveat of 6 months after date of knowledge, they must still be brought within 3 years of the commission date of offence as an overarching and encapsulating time frame. So that's for allegations such as driving after making false declarations, failing to notify the Secretary of State about disability, driving after any such failure, failure to surrender your licence, obtaining a driving licence whilst disqualified, making false statements, or issuing false documents. As you'll appreciate, there is a common theme there, that if the failure or the timeline arises as a result of false information or conduct on behalf of an individual motorist, it's 6 months from when that becomes known to the police, and in any event within 3 years from when that occurred. Once the information's been laid and a summons is issued, should the alleged offence fall within the definition of what's known as specified proceedings, then the court can give you an opportunity to issue or tender your plea by post. The process is commonly known as the Single Justice Procedure Notice, and with the Single Justice Procedure Notice in the post, it's worthy to mention at the outset that often this is where the offence is not deemed necessary for a disqualification, either a discretionary disqualification due to the severity of the offence or as a result of the accumulation of points. So if you do receive a Single Justice Procedure Notice, it will be accompanied with details of the allegation and a response pack, a plea form and a statement of mean, because that's how they ascertain the levels of fine that are going to be imposed with any sanction. So upon receipt, the first thing to do is check the time limits, check that the police are in time with bringing the charge, but also check the time limits for responding to the court, and it's usually a period of 21 days. Now, there is no requirement for evidence to be served on you at that stage, and you ultimately have 3 options. Number 1 is plead guilty by letter with supporting mitigation, plead guilty but request to go to a court hearing. Now, you would frequently request to go to a court hearing if you are accepting the charge, therefore tendering a guilty plea. However, you're disputing the severity of the facts, or you're disputing the severity of the allegation, or likewise you are a new driver, or you are aware that you're potentially going to receive a number of points totting you up to 12. Now, some would say, why is that not self-incrimination? If you're going to say to the court, well, I want to come to court because I'm aware that if you give me 3 points, I'm going to get to 12. Actually, it's a powerful mitigation tool showing an open and honest, transparent approach, and actually preserves your credibility, because invariably, once the court receives your documentation, they will do a license check. And if by way of error, they should not have sent you a single justice procedure notice, and in fact, due to the accumulation of points, i.e. you're on 9 points, you've been done for speeding, it's inevitable. The minimum is 3 points, you're going to be a totter, a ban is on the horizon, you're invariably going to be called in. So it's best to preserve your credibility from the outset. Or finally, the third option is you simply tender a not guilty plea and request a trial. If that's going to happen, you tick the relevant box, you explain in brief what you take dispute with in terms of the allegations, and the court will set trial date, and they, if necessary, set directions as to what either party needs to do in preparation for that trial. Now, a few things to bear in mind. It's always worth seeking legal advice if you're unsure on either the allegation, or you're unsure on the ingredients of the offence, or you're unsure on if there's an applicable defence. For example, you may well be careless driving, but if you are carelessly driving, for example, down a hard shoulder to attend to an accident that you've been made aware of, there is a defence of duress or necessity of circumstances. Therefore, you may well actually have a legal defence to what is ordinarily seen on an objective view as careless driving. It's always important to remember that you get credit for your prompt guilty plea. So if you do plead guilty at the first opportunity, you get a third discount on any sanction that's imposed in terms of financial penalty and such like. And it's also important to bear in mind that there is that opportunity to engage in negotiations with the prosecution. If a single justice procedure notice, and I'll use the same example as before, alleges speeding and alleges failure to furnish information, or failure to furnish information carries a minimum of 6 points, whereas speeding may well be a 3-point matter, and therefore it may be that you can negotiate with the prosecution and say, if we plead guilty to X, will the prosecution confirm they withdraw Y? So it's important to understand those concepts and those measures before simply filling out the form and sending it off. Can we go to the next slide, please? So it's always paramount to understand the circumstances surrounding an offence together with the alleged conduct itself, in particular when special reasons are to be considered. Now, the majority of road traffic offences carry either a mandatory endorsement of penalty points or a driving disqualification. However, in some circumstances, it may be possible to put forward special reasons argument, which, if successfully argued, may result in the avoidance of the imposition of a penalty altogether. A special reasons argument can be put forward in circumstances where, although technically under the strict law you are guilty, but actually due to the circumstances you are morally innocent, so to speak, and it'd be morally unfair for you to be punished. Now, as mentioned before, special reasons can apply to most motoring offences. However, the argument put forward must be relevant to the case and must directly relate to the commission of the offence. It cannot be specific to an offender. It must be, as a result, directly connected to the commission of the offence. Accordingly, the reason cannot amount to a defence in law, and therefore it must be an extenuating circumstances the court ought to properly take into consideration when imposing a sentence. Now, just pausing there, I'll give you an example of that careless driving, the driving down the hard shoulder, the necessity of circumstances. That may well be raised as a defence. If the court do not accept it's a defence and therefore you are guilty, you can still raise potentially special reasons because the court have already acknowledged it does not amount to a defence. So it's important to look at the strategic way in terms of deploying a defence and actually consideration of special reasons in the same token. If special reasons arguments are to be raised, the onus is on the defence to satisfy the court on the balance of probability, so not the same criminal standard as required by the prosecution. And if it's accepted, the court retains the discretion. So even if the court accepts that special reasons apply, it doesn't necessarily mean there is no sanction. It means it's their discretion. They can reduce the minimum period of a ban. They can reduce the number of points they ought to ordinarily impose. And it's fair to say that special reasons or special reason arguments are bespoke and unique to specific circumstances of a case. However, over the course of time, there are some common instances that have emerged. So, for example, driving in an emergency situation. Driving in an attempt to escape a serious threat of violence. Yes, you may well be speeding, but there may well be a genuine reason as to why that's happened. Driving a very short distance, driving over the drink drive limit because your drinks have been laced, or you've asked for singles, but a pub has served you doubles. Driving without a license, where unbeknown to you, your license has been revoked, so you wouldn't have been none the wiser. Driving without insurance, for example, where your partner is responsible or your employer is responsible for arranging your insurance and did not tell you that it had been cancelled. So they are some of the special reasons, sort of examples that can be deployed, and therefore it's always important that even if you are guilty of committing an offence, that one always considers the circumstances surrounding it, because it can have a significant impact on the potential ramifications and outcome, both in terms of the incident and how the court deals with it, but also your overall driving record and how the outcome of that incident or the outcome of that charge can have a consequential impact. If we go to the next slide, please. So I've talked about endorsements and disqualifications, and in relation to endorsable offences, i.e. where the court can impose penalty points, whenever the magistrates have the power to give you penalty points, they equally have the power to impose instead a discretionary driving ban. And it's one or the other. You cannot get points and a ban. Now, discretionary bans are most commonly imposed for speeding offences and driving without due care and attention, or driving with no insurance. But the magistrates will usually, using the speeding example, because I'm going to come on to the next slide in a moment, but using a speeding example, the courts will usually impose a driving ban for the more serious offence. So for a speeding offence, you're more likely to get a ban the greater your speed over and above the prescribed limit. Now, there are myths versus reality insofar as I think a lot of people believe that if you're caught doing 100 miles an hour, you're automatically going to get a driving ban. Well, that's not quite true. The court's guidelines suggest they should consider a ban, but in the alternative, they can equally deal with it by imposing 6 points. And I give you an example. A court could be dealing with a motorist that has no points on his licence, good character, no speeding offences, and they may actually have regard to the impact of a driving ban and give him 6 points on the basis that if he does it again, he looks at potentially accumulating 12 and becoming a totter. Now, on the likewise contradiction, a court could have an individual having done 100 miles an hour. Instead of giving him 6 points, instead of giving him a driving ban, they may consider giving him 6 points in the knowledge that doing so will then accumulate 12 points because he's already got 6 on his license, and therefore he'll serve a longer ban. There are legal arguments that around whether that's lawful or not, but it's been done, it does happen, and it's something to be alive to. Now, magistrates are advised, however, that for speeding bans, certainly discretionary bans shouldn't normally exceed 56 days. And 56 days is an important feature, because if you are banned in the future, in the following 3-year period for any offence, if you've already been banned once before for a 56-day period or more, any starting point of a ban tends to increase significantly and indeed could double. And it's an important factor to have in your minds when dealing with submissions to the court. If we could go to the next slide, please. So this is what the magistrates court look at when they're dealing with sentencing speeding offences. Down the left-hand side in the first column, you've got the speed limit, and then thereafter you've got 3 categories. The first being just above the limit. The furthest category to the right being the lowest category, suggesting 3 points. Then the middle category, which suggests either 4 to 6 points or a disqualification. And just pausing there, up until 2017, the focus was on issuing 4 to 6 points or disqualify. It's a slight change, but the guidelines have been amended effectively to reflect that now the onus or the emphasis is on disqualification first, or alternatively 4 to 6 points. And then the final category is disqualify 7 to 56 days or impose 6 points. Now, there are various factors, there are various submissions that can be made. If, for example, and I'm going to take the middle category, if you are on 7 points, you may well want to argue that your case is dealt with by penalty points, but that they deal with it by issuing 4 penalty points. There's always the factor you run the risk that if they decide to issue 5, you find yourself having accumulated 12 and liable for a 6-month disqualification. Likewise, if you are on 9 points, you may ask the court, and you're in the middle category, you may ask the court to deal with it by way of a disqualification for a short period of time, days/weeks, and therefore just be very careful rather than losing your ability to drive. If we could go to the next slide, please. Now, you've heard me talk about totting up and accumulating 12 points within a 3-year period and a mandatory 6-month ban. That's what's known as the totting up provisions, and I'm going to explain that and touch on exceptional hardship. Totting up provisions are found in Section 35 of the Road Traffic Offenders Act. In short, it explains that if you receive 12 penalty points in a 3-year period, you render yourself liable to a mandatory disqualification for a period of 6 months, following which your licence is clean, but you will not have a licence for 6 months. You cannot drive. It's an obligatory disqualification, and in fact, that is the minimum term. It can be greater. And if you have had a driving ban for 56 days or more, in fact, it will be greater. It will go. The starting point will be a year. When looking at the 3-year period, it's the commission date of the offence that's the important date. Some people often think it's when you got the 3 points. So if there's a delay before it gets to court, for example, on previous matters, and the onus and burden on the court, on the prosecution, is to identify those, but they're inevitably recorded on your driving record, which is all online, and so you can actually check it yourself these days. Now, if you are faced with that predicament, there are 3 ways to avoid the ban. Number 1, defend the allegation, and if you're successful, no sanction. Number 2, argue special reasons to reduce the impact of the sanction, i.e. points or a driving ban. But often that's either not available, or if advanced, is not accepted. So the final option is, if you are confronted with a situation where you have received 12 points in a 3-year period, the only way of mitigating the normal consequences of that 6-month ban, as the usual, is to argue what's known as exceptional hardship. Now, there is no precise definition of what amounts to exceptional hardship, but it's established as to be something more than the usual consequences. For example, a driving ban invariably may well lead to a loss of employment. That's not good enough for exceptional hardship. For exceptional hardship to chime and to be engaged, it needs to be something a bit more than that, and usually it needs to be the impact on third parties. For example, you could be a skilled labour worker, and actually you losing the ability to drive means you can't do your job. Your employer may suffer in terms of the difficulty in finding someone else to do your role. More readily, if you are the breadwinner, the only source of income in the house, loss of your employment may well result in the family not being able to pay the mortgage and potentially having to relocate and such like. So it's the impact it has on third parties more than it has on yourself. For example, if you have a relative that solely relies on you taking them to hospital appointments, an elderly relative solely relies on you taking them to do their shopping, there is no one else, you are the only person that can assist, then the court is minded to allow you to drive. The onus and burden is on you as the individual, again on the balance of probabilities. And like I say, they could reduce that 6-month mandatory ban down to 2 months, or in fact impose no ban whatsoever. If that was the case, you'd carry on driving with 15, 18 points on your driving licence, whatever it is, 12 or more. But the court would register your reasons. They would register them on the court record. They would be registered so that you cannot use the same reason for the following 3 years. That does not mean that if you are driving on 15 points and you get accused of another speeding offence, it does not mean you cannot argue exceptional hardship. You can, but it must be a different reason to the reason you initially used. Now, I say that because it's important that if you are going to court and you have potentially 5 legal arguments of exceptional hardship, you may only want to deploy 3 in case you need to use 2 in the future. There is an inherent risk that the court actually need all 5 to believe you and make it significant. So I sort of say that because there is a right of appeal, and your right of appeal against a decision if the court refused those exceptional hardship, the right of appeal is to a Crown Court. But you've got to bear in mind that if a magistrate's bench has not accepted your grounds of exceptional hardship, a judge sitting in the appeal court is unlikely to as well. And a judge is more likely to press for explanations and reasons than perhaps a CPS prosecutor who's dealing with a number of cases on that particular day. So if we go to the next slide, please. that's given you a broad overview of the regime, from dealing with the police, dealing with accidents, what you're required to do, court proceedings, interviews, arrests, potential outcomes to your overall licence, and the factors you need to take into consideration. I thought it'd be helpful to touch on some of the recent developments that have also sort of come into play already as of the last few days, or are due to come into play later this year. So I'm sure many of you have heard of them because they've been publicised widely in the press. But there have been changes to the highway code that have been implemented, which talk about greater distances for cyclists if you're in the car going past them. For the first time, there's a greater responsibility in terms of a hierarchy system. So pedestrians have more of a right of way at junctions, as do cyclists, and so on and so forth. Now, I say there's changes to the highway code, breaking that. Many of the things in the highway code are legal requirements. Many of them are equally not. A breach of the highway code does not mean you've committed a criminal offence. For example, if you are alleged of careless driving, and many of the things that they are accusing you of are in the highway code, you haven't necessarily committed a criminal offence, but the highway code is used as evidence in terms of a yardstick of what is expected by a prudent and competent driver in all the circumstances. And if you were going to make an argument that you have not been careless but not followed the highway code, you need to be ready to explain why. So I just point out those because, you know, for example, you've now got to leave 1.5 metres or 5 feet when passing a cyclist. If you're turning into a junction and there's a pedestrian crossing, you need to let the pedestrian cross. Cyclists are encouraged to go side by side with one another. And in fact, if there's a cyclist on your right-hand side and you're turning and it's wanting to turn left, you are now expected to observe it in your blind spot and let it pass first. There's going to be changes to mobile phone laws. Naturally, everyone's aware you can't use your mobile phone while driving. The law changed previously from 3 points up to 6 points, but it was about the transmission or using a device that could, it was a two-way transmission. So going on social media, making phone calls and such like. However, as you know, when there's accidents, people get the phones out, they take photos, they take videos, they post on Instagram. People scroll through their playlists, they're sitting in traffic, playing games. All of that's now encapsulated within the offence regarding mobile phone laws. In addition, drivers can now find themselves being fined £70 by local authorities, so not just the police but the council, for performing bad manoeuvres. Or before, they could only do it if councils could only do that if they were dealing with motorists in bus lanes or in yellow box junctions, but that's widened now. And there's also going to be new laws allowing councils to issue £70 fines for those that park on pavements, heavy residential estates, new build estates where parking is limited and such like. In addition to that, all new cars from July the 6th, unless that date changes, must be built with speed limiters in place. It's one of the most controversial moves for motorists I think in this year. The rules came in the EU back in 2019 when the UK was still part of the EU, but the rule never sort of found its way into UK legislation. However, it's now coming into force. So that gives you a broad overview of sort of 10 key areas from, as I've said, from the onset to throughout. There are invariably intricacies within all of those areas, and indeed more significant areas that I haven't touched upon, but it's to give motorists and you out there a broad overview of the issues likely to arise on a day-to-day circumstances. If we go to the next slide, please. Before we take any questions, we're going to be sending out the recording to everyone that signed up to today's webinar tomorrow morning. We'll also include a link to a very short feedback survey. We'd really appreciate if you could complete that so we can make sure any future webinars are equally helpful to you. As I said at the start, this is one of a series of webinars. Our next webinar is Farm It, Develop It, or Produce Energy on It, and how to maximise the opportunities from your land. And that's aimed for farmers and agricultural businesses and owners. And that's going to be on the 9th of February. If you are interested in our future webinars or any of those on the screen, please do visit our website or our Eventbrite page and sign up. So without further ado, we'll now take some questions.
Thank you, Ted. We have had a couple. I'm keeping them anonymous today. So first of all, what is the difference between careless driving and dangerous driving?
Yeah, good question. So it's effectively a quantitative one when considering the seriousness of conduct. careless driving is effectively defined as when a standard of driving falls below what would be expected of a competent and careful driver. There are various situations that may amount to careless driving, but in each instance, the driver will be regarded as driving without due care and attention, or driving without reasonable consideration for other road users. For example, tailgating, overtaking on the inside, running a red light, although that's an offence in its own right, driving while distracted, and actually it can include intentionally driving through a puddle and splashing pedestrians. The penalties for careless driving vary significantly. At the very least, they can be dealt with if they're minor in nature by a fixed penalty, 3 points, £100 fine, and in more serious matters, they go to court and you can get a driving ban up to 9 points and up to a fine of £5,000. Now, dangerous driving, on the other hand, is a lot more serious. However, the definition of dangerous driving is where the standard of driving falls far below what would be expected of a competent and careful driver. As you can see, the difference is effectively one word, far below and just below. So there's just that one word that separates the two. And it may not seem like much, but in reality, the two offences are very different. Dangerous driving is much more serious and deals with instances such as racing, aggressive driving, driving whilst under the influence of drink and drugs rather than being in an accident, driving despite you knowing that you're unfit to drive, driving a vehicle that you know is defective and unroadworthy, and therefore the standard of driving may be sort of deemed dangerous, or it might be the condition of the vehicle as well as actually the driving. So it's important to note that you don't actually necessarily have to cause an accident to fall in that dangerous category. If you, I'm going to use the term boy racers, but if you have boy racers swerving in and out of busy traffic, not signalling, you may find that they're accused of dangerous driving. The outcome on dangerous driving, if you are convicted for an offence, the penalty is hefty. Firstly, it's a mandatory disqualification of 12 months rather than your 3 points and a £100 fine. And if it extends upwards to the Crown Court, they can extend that up to a 2-year ban. They can also hand out between 3 and 11 points, so they can still deal with points as well as that unlimited fine. And in the most serious cases, you can actually be sent to prison for up to 2 years. So it's almost down to severity and what you get up to. But as I say, and I think I've mentioned it throughout, one of the arguments you need to be making at interview if you are accused of dangerous driving and you are accepting the conduct, is whether that conduct falls within dangerous category or careless category, and how that's presented.
Great, thank you. Next question. Which is taken as the correct record of speed, your car's speedometer or what a sat-nav shows? These are slightly different in my car.
So, in fact, neither of them are accurate. It's going to be a calibrated device. Now, your car will have a calibrated speedometer. It's going to be more accurate than a sat-nav. A sat-nav is reliant on a satellite signal, and there's many interfering factors. When I say they're different, we're talking trivial amounts. It's worthy to note that the police are required to calibrate their speedometers that record speeding offences at least once a year. Now, the reason many people will have heard that you are given a discretionary grace period, so 10% plus 2. So if the speed limit is 30, you often don't get prosecuted until you are doing 35. Now, that is guidance, that is true. However, if you are doing 31 and a 30, you are guilty of speeding. The police can prosecute you. They would need to show that they have prosecuted everyone on that particular day with that device, rather than being discriminatory towards certain vehicles and others. The reason that police don't do that is because there will be technical arguments if you are accused of 31 and a 30 about whether or not that's accurate or not, which is why they have that grace period. But certainly the best way of actually doing it is if you go past one of those electronic speed signs that's not camera but tells you your speed, either gives you in green writing or red writing to slow down. And if you are doing 30 in your car, you'll often find your car is calibrated to be doing a mile or so more, and that the reading will come up as 29 rather than 30. But in short, to answer your question, your car is going to be more accurate than your sat-nav.
Thank you. Next, how do you evidence a valid MOT?
So a valid MOT can be evidenced in two ways. You're going to get the MOT certificate on the time of you having the MOT undertaken. Equally, the government website. If you type in the registration, it will tell you whether the vehicle's taxed and whether it's got an MOT. However, it's worthy to note that and not many people realise this, your MOT is valid for a period of a year. If you were pulled over and you're told your vehicle was in unroadworthy condition, or you sold your vehicle and you were accused of selling it in an unroadworthy condition, you may well think that having an MOT demonstrates that's inaccurate, and actually you're exonerated. On a strict legal interpretation, your MOT is only actually a true reflection and valid at the date and time it was carried out as per the certificate. So therefore, if you have a valid MOT, but 3 months later you have a defective exhaust, it's not sufficient to say, well, of course the exhaust is fine to the police, for example, because I've got an MOT saying it was fine. Because a police officer will simply say, well, it could have deteriorated, it could have been replaced. So your MOT is only valid, although it's valid for a year, it's only a true reflection on that particular date and time. But if you're ever requiring to present your MOT certificate, it will be the hard copy certificate, and you will also be able to direct an officer to the online portal. You've got to bear in mind, many of the police vehicles are fitted with devices that can simply monitor your number plate and check whether it's taxed, MOT'd and such like instantly.
Okay, next, what are the risks of falsely nominating someone on the form requesting the identity of a driver?
Good question. So we've all heard of that. Well, I say we've all heard of it. Back in the mist of time, we've probably all heard of new drivers. So 18-year-old that's on 3 points, worried that if he gets another 3, he's going to lose his license, or husband on 9 points, needs his license for his job, worried if he gets another 3, he'll lose his career and such like. So when that form comes through, there's always been that temptation to nominate someone else, nominate your wife, nominate your dad. And in essence, it's perverting the course of justice. It's perverting the course of justice twofold. The person who's filling out the form and nominating someone else falsely, and the person who's letting themselves be nominated and accepting they're the driver when they're not. You've got to bear in mind that if you falsely nominate someone and you are identified, you're going to be perverting the course of justice. And there's been a number of high-profile cases where not just celebrities, MPs and alike have gone to prison. It's an imprisonable offence, and what could have been effectively a 3-point speeding fine or even a 6-month ban has turned into a 4 or 5 month prison sentence. So the risks are huge. Certainly bearing in mind that the police may well be able to prove, if you are nominating your wife, who you are suggesting has long, beautiful blonde hair, and the photo produced by the police shows a man with a moustache, short hair, it's clearly not her, it's a false declaration, and you are likely to be prosecuted, as is she likely to be prosecuted. Likewise, if you nominate someone who doesn't have valid insurance to drive your vehicle, for example, caught speeding, form comes through, you nominate someone without even thinking, the police then ask you to produce documentation to attest to the fact they are validly insured to drive your vehicle. You can't do that, and therefore you are actually prosecuted for permitting someone to use your vehicle without insurance, which is 6 points, which is almost worse than the 3-point speeding offence in the first place. So there are a number of inherent risks, but the bottom line is, if you are caught perverting the course of justice, you're going to go to prison if you are charged and convicted of it.
Thanks, Tej. That is all the questions we've received. Thank you.
Fantastic. Thank you very much. So thanks for joining me today. If there are any questions that haven't been answered or further questions, please do let us have them, and we'll get back to you as soon as possible.